disenchanted with those guys is that they would cease.
How do you do that? How do you...
Is the L Sapina. This is the notice of default.
Homes in this cold weather in Ohio is going to be 10, 20 below zero. Don't leave your home. Because you know what? When those companies say they have your mortgage, unless you have a lawyer that can put his finger or her finger on that mortgage, you don't have that mortgage. And you're going to find they can't find the paper up there on Wall Street. So I say to the American people, you be squatters in your own homes. Don't you leave. In Ohio and Michigan and Indiana and Illinois and all these other places where our people are being treated like chattel. And this Congress is stymied.
I mean, we're talking about human.
You can...
Yeah, they took out insurance on a loan known as WMALT 2007 OA3, and that's its intrusive number, is it? Haunch number? And they took out insurance on it and it was paid off per a Bloomberg report 17 times. I have a copy of the report, but it doesn't matter. They are getting rulings out of the courts. The courts are not even looking at the reports to make the determination of the fraud that is quite evident. That same property was taken over by SPS after I was approved for a loan modification, and that was 3 years ago. SPS took it over. I've applied just with SPS 7 times, and just before the takeover I was approved by Chase. Then I called and said, your loan is now being serviced by SPS. SPS has treated me just terrible. I'm tired of having to correspond with them. There's a new homeowner Bill of Rights addendum that took effect January 1st, 2014 that says once you submit a loan modification, they have 5 days to let you know if there's anything else they need. If not, they're supposed to remove the notice of default. All this stuff together makes it really nice. You know, where some of this information might be subpoenaed sometimes. Rocco's in his truck. Clear the way, you guys.
Oh, wow.
Camera? You're on. Let's roll it. This is Maria McDonnell.
Hi, everybody. Hi, nice to meet you. It's a beautiful day in Santa Barbara.
The best forensic expert in all of the United States. She dissects the reports and follows a paper trail of money.
I follow the entire life cycle of the loan. I can audit the loan from the application all the way through the early disclosures, through the closing, do the forensic accounting, follow chain of title, trace the securitization of the loan, and find the flaws that hopefully can help people save their homes. So hopefully that's what I'm here to do.
Great.
You're in the right place, in the right county, at the right time.
Man, I guess I am.
We have massive fraud going on here.
Can't believe the situations and the good people, you know, that I'm meeting who should never be in this situation. It is just...
1, 2, 3, 4, 5, 6 victims right here that are getting bad rulings from the same judge known as Judge Geck in the Santa Barbara Superior Court. We have the evidence, we have the experts, we have the toxologist. We know the crime has happened. The judges are looking the other way to the crime scene, and we are all joining forces to get momentum, to get justice under one nation, under liberty. Thank you. Back to Maria.
Oh, well, I don't know quite what to say, you know, except I have to write a very important letter today to your Attorney General, Kamala Harris. My friend, Svetlana Ivanova, is going to attend an event tomorrow, and she will be meeting the Attorney General. And so hopefully I can compose a short letter asking her to devote some resources to really looking into this. I mean, you have to get the prosecutors have to get to the root of these problems. I mean, this is unnatural. And I know from doing the work that I've done, I know how these loans were designed to fail from the inception. And really the evidence is there if you know how to find it, document it, and so forth. I wish I could clone myself because so many people are in desperate need of this type of help. It's a rare skill set that can actually do what needs to be done here. So hopefully, you know, even after I leave, we'll have an opportunity to work together and try and see what's really going on. I'd be interested in seeing some of these judgments coming out of the court, because if there is, and I don't know that there is, but if there is judicial corruption or prejudice, I mean, that really needs to be looked into.
After you look into it, will there be a possibility of getting Judge Geck and some of the other crooked judges removed from the office?
Well, that's a good question, and it's been done before, I'll say that.
What happened in Seattle after you audited the Seattle County Recorder's documents?
They tried to suppress the results of my report. Yeah, we conducted really an intensive examination of a population of just under 200 assignments of deed of trust. The mission was that I was given by the Seattle City Council to determine whether those assignments of deed of trust were valid in light of the Washington Deed of Trust Act and statutes, and in particular in light of the Washington State Supreme Court's decision in Metropolitan Mortgage Group versus Kristen Bain. And I found that none of those were valid because they involved assignments that were executed by certifying officers of mortgage electronic registration systems. And really, when you dig deep, you see that MERS has nothing to assign, and especially in a state that uses a deed of trust as opposed to a mortgage. MERS can't even hold legal title. So what is it then that they're assigning? All they're really doing, but it's a sham, is these MERS assignments are just simply indicating that the mortgage loan is being deactivated in the MERS system. Well, who needs to know that? But that's what those assignments are about, and they're being taken as valid transfer documents, and they are anything but.
Are any of the MERS documents and transfers valid? Any of them?
Oh, that's a good question. They might be assigning something, but the question of what they have to assign is going to change depending upon whether the instrument is a mortgage or a deed of trust. So if it's a mortgage, I'm from Massachusetts. Massachusetts is also a non-judicial foreclosure state. In Massachusetts, the law in our Commonwealth acknowledges that the note and the mortgage can be separated, can be held by different entities. However, in order to foreclose, they have to be rejoined, reunited under one principle before the statutory power of sale contained in the mortgage can be enforced. So in Massachusetts, you can have a MERS assignment of the mortgage to another entity, theoretically, because that's permissible under state law. But in any given case, is that valid? Probably not. If you have a loan that was securitized or sold into the secondary market to Freddie Mac and Fannie Mae, it might not be. So really boils down to some individual facts. But you asked me about the Seattle audit. There was a concerted effort to sweep everything under the table because actually it would have...
By who? Who made that concerted effort? I mean, it's easy to say there was, but who was they?
Sure. I can tell you who they are. It was the auditor's office and the city attorney's office. They didn't like some of my analysis and conclusions, which were well-founded. It's what I would do in any expert report, to lay the proper factual foundation, conduct the research, and then draw rational, factual conclusions. Their excuse was, well, those are conclusions of law, and you're not an attorney, and we didn't hire you to do that, which is not true. They actually did. They wanted me to determine whether those deed of trust assignments were valid. And so the city auditor wrote a 3-page memorandum that is merged on top of my report and then turned that into the Seattle City Council. I got wind of that, just an intuition I had, on the morning of when the presentation to the City Council was to be held. And I had enough time to read that memorandum and write my own letter to the chairman of the committee who ordered the audit, and showed him why the memorandum was contrived. It's simply off base. But it was an attempt to subvert the entire project, to, well, in the memorandum they say that they concluded that they should not endorse the report. And Councilmember Licata questioned the assistant city attorney on this and said, well, you wouldn't endorse anything anyway if you didn't research and write it, correct? So we shouldn't be talking about whether you're endorsing the report or not. You know, the report is for informational purposes. So it's very interesting. There is a video of that hearing. Mr. Council Member Licata he got right to the heart of the controversy there between the city auditor's memorandum and my letter. And but in any event, nothing really came of it, although my report is being submitted in various state and federal courts in the state of Washington to back up positions in an individual case that a particular assignment of the deed of trust is also not valid, and here's why.
So the process is still going on. City attorney didn't lose his job. The city auditor didn't lose his job.
Oh, no.
Recorder didn't lose their job.
No. Oh, and that's another thing. So part of what we uncovered as we tried to gather the records from the King County Auditor's Office is that we found a number of problems that are serious because they are not properly and consistently indexing MERS in the grantor-grantee index. And this is really a huge problem because you can't just, you don't know if a particular deed of trust names MERS as the nominee for the lender if you don't actually download and open the document because they haven't properly indexed MERS.
So this would this allow them to commit fraud then? More easily?
Well, it removes a tremendous amount of transparency, and it had serious implications.
And the city attorney had no problem with this.
All I can say is you should read the memorandum written by the city auditor, which was co-authored, I believe, by the assistant city attorney, Kelly Stone, and the assistant city auditor, Virginia Garcia.